We are live in 3 seconds. Good morning, everyone. Welcome to this webinar today on expeditious disposal of commercial disputes. My name is Chetan Singh. I'll be your host for this webinar. And this webinar would be divided into two parts, wherein Birendra Saraf sir would be taking us through the entire webinar. And in the last 10 minutes of the webinar, he'll be addressing all the questions through the question answer round. He will also be sending across a note post the webinar, which will address more queries that you may have. In this webinar, I have with me Mr. Birendra Saraf sir, and Sudhakar Yellagara sir, who's a Joint Director of Maharashtra Judicial Academy. Yellagara sir, I would request you to please introduce Birendra Saraf sir, and then Saraf sir can take ahead this session. Yellagara sir.
Thank you, Chetan.
Sir.
A very good morning to honorable judges and today's guest lecturer, Dr. Birendra Saraf sir. This is a right time to utilize the lockdown period. Because of this lockdown, we are unable to conduct the sessions at the academy, and courts are also not functioning regularly because of this lockdown. In order to make optimum use of this time and the infrastructure available, with the initiative of the Honorable High Court, especially our Honorable Chief Justice, our Honorable Officiating Director, and our Honorable Judges from the registry and all governing council members also, we started this series of webinars. And today's current topic is commercial courts expediting the commercial disputes. Today we are having an eminent speaker, Dr. Birendra Saraf, who is a senior counsel in the Bombay High Court, having practice in diverse subjects, including proceedings arising under the Arbitration Act, commercial laws, intellectual property laws, town planning, civil disputes, and also matters relating to fundamental rights enforcement. Dr. Birendra Saraf is a gold medalist at Bombay University in all 3 years of law. He was conferred with a PhD for his research on this subject, judicial intervention in arbitrations in India. Currently, he is the secretary of the Bombay Bar Association, which is one of the oldest bar associations in India. Mr. Chetan has already explained how we are going today in this webinar. After this session is over, I will have 2 minutes again with you, and it's my pleasure to welcome Dr. Birendra Saraf sir. Sir, welcome to this academy and this webinar. And in the beginning, I must express my thanks to the SCC Online management and their team for this cooperation. Thank you very much, sir. So now you can start, sir.
Thank you so much, Mr. Yellagada. At the outset, I would like to express my sincere gratitude to the Maharashtra Judicial Academy and Mr. Yellagada for inviting me today. It is my absolute pleasure and privilege to have this interactive session and share some thoughts with the learned judges. The queries sent and the kind of issues raised always sets us thinking on a relatively new legislation, and that is a greatly enriching experience also for us. So thank you so much for sparing time and sending those queries, and thank you so much for inviting me. What I'll try to do is, my idea today is not to find an answer to all issues, but rather to leave you with thoughts which will, kind of let you decide as and when the issues arise, because there are vexed issues. This is relatively a new legislation, and there will be many issues which will be coming before you of which you will be the best judge after considering the arguments of both sides. So I will not be trying to find answers on all complex issues of law. Rather, I would like to place certain aspects of those issues before you and leave you with thoughts which you can then invoke as and when the issues arise before you. So the Commercial Courts Act was enacted in 2015, but it had a long journey from 2003. Why I say this is because sometimes when a legislation is a relatively new legislation, the legislative history and particularly the Law Commission reports are good aids in deciding certain aspects which may arise, though often it is a common principle of law that when a statute is clear, then external aids of Law Commission reports, etc. are not very relevant. But there are situations when the entire history of the development of that provision becomes relevant and can be a good aid for understanding what it is. So the entire process started in 2003 with the 188th Law Commission report. It was really a suo motu report of the Law Commission, and what was happening was because of delays in disposal of commercial disputes in India, the world at large was believing that doing business in India was not a very easy exercise because the dispute resolution process was delayed. And at the same time, it was found that courts in UK and US had taken over jurisdiction on issues where the ordinary natural jurisdiction would have been in India on the basis that the disputes are not getting decided for almost 20 to 25 years. Now, the courts may not be blamed for that because ultimately it is the burden of the work which the courts have. So it was thought appropriate that there should be a procedure and a special legislation in order to ensure that commercial disputes can be decided expeditiously. So it started with the 188th Law Commission report. There was a conference of the Chief Ministers and Chief Justices in 2009, which also reiterated the need of a commercial court. The matter went on through various stages. In the Lok Sabha, it approved it. In the Rajya Sabha, there was a lot of objection to it on the ground that the courts are already overburdened, that this is an elitist legislation because it gives preference to commercial disputes, but that's not for us to consider and see. But finally, that bill got withdrawn and the Law Commission was invoked again and the matter was referred back to the Law Commission, leading to the 253rd report of the Law Commission. This report of the Law Commission, the references of all these reports, etc., the case laws which I will be referring to are all in the note that I have circulated. So I would not be giving you details of that. They can be easily had from the note. So the 253rd Law Commission report is really the genesis of the Commercial Courts Act. And it gave and formulated the entire scheme of the Commercial Courts Act. A reference to that Law Commission report helps because at times it is helpful to see what was the recommendation of the Law Commission and how the act finally culminated, to understand that what part of the recommendations were not accepted also. That also is a little relevant at times. That act was, initially it was passed as an ordinance and thereafter the act was passed. However, within 3 years, it was amended again and the scope of the act was expanded, and the 2018 amendment amended the 2015 act, and that is where we stand today. So there was a query that whether the 2018 amendments have a retrospective effect or prospective effect, to which there is a provision in the Amendment Act itself, which says that the 2018 amendment will only apply to suits which are filed after the coming into force of the amendment. So therefore, the 2018 amendment does not have retrospective effect, but has prospective effect. So that is section 19 of the Amendment Act of 2018, which clearly sets out that it will apply to only suits which are filed after the amendment. Now, what was the original scheme of the Commercial Courts Act? As you all are aware that the Commercial Courts Act initially contemplated only commercial courts at the district judge level and at the high court level. So there was supposed to be a commercial court at the district judge level, and there was to be a commercial division of the high court in courts where there was largely original jurisdiction, etc. And then there was to be a commercial appellate court in the high courts comprising of 2 judges. So there were commercial courts at the district court level, there were commercial division at the high court, and a commercial appellate division in the high court, which was to act as a common court of appeal arising from commercial courts and commercial divisions. And the commercial disputes, the value was a minimum of 1 crore of rupees. Now, the original idea was that high value commercial disputes should be decided expeditiously, and they should be decided at the state at a level of a district judge. But the 2018 amendment expanded the scope of the Commercial Courts Act and even permitted the commercial disputes to be decided by judges below the level of the district judge, and it expanded, it reduced the specified value from 1 crore to 3 crores. It also provided for appellate courts at the district level. So today we have a situation where you have 2 hierarchies of of the commercial courts. And if you just come to this note, I've set out a small chart. Chetan, can I have the note, please? If you just see this structure in paragraph 35 of the note, now we have 2 kinds of structures. You have the commercial division of the High Court, and you have the commercial court at district judge level, from which appeals lie to the commercial appellate division of the High Court. And the parallel hierarchy is where there is a commercial court below the district judge level, from which an appeal lies to the commercial appellate court at a district judge level. An issue which arose was what happens in a situation where the original commercial dispute is decided by a judge below the level of a district judge, and from there an appeal is decided by the commercial appellate court at the district judge level. Will a section 100 CPC apply? Well, there is no removal of the section 100 from the Code of Civil Procedure. So to that extent, it is quite possible to contend that a second appeal on an issue of law will arise from the commercial from a decision of the commercial appellate court at the district judge level. So that's an issue which will may arise in future, but that would be for the High Court to decide as and when such an appeal is filed. Now, what really is a commercial dispute is something which is of great significance and on which a lot of queries have been raised. Chetan, you can remove the screen. So that is set out in the Commercial Courts Act in section 2, which is the definition clause, section 2C. Now the opening part of this provision is of extreme importance because it says commercial dispute means a dispute arising out of. So the use of the word means has been interpreted by the Delhi High Court to say that it is an exhaustive definition. It is not an inclusive definition. And therefore, only if a suit falls in the categories set out in section 2C can it be treated to be a commercial dispute. Otherwise, it cannot be treated as a commercial dispute, because if we give an expansive definition to the term commercial disputes, then even non-commercial matters can get included, and the whole purpose of the Commercial Courts Act, which was the expeditious disposal of certain categories of disputes, may get defeated. So therefore, we need to see that we do not unduly expand the horizons of a commercial suit. Now, important part is also that the use of the word arising out of. So though these are the only categories, but within the categories, the scope might be a little wider because of the term arising out of. So it need not be exactly a transaction relating to aircraft, but may arise out of a transaction relating to aircraft also. So it is that word arising out of is a little broad ambit. So as long as it falls within this class, then within this class, it may have a wider meaning. So there are some judgments of Delhi High Court and Gujarat High Court, and one judgment of the Supreme Court dealing with commercial disputes. And I've set out those judgments. The Supreme Court has accepted the Gujarat view to say that the definition of a commercial dispute should not be unduly expanded. The purpose of the Commercial Courts Act was to ensure that commercial disputes which are falling in these categories should be decided expeditiously. Now, some of the categories of cases which are set out in section 2C may become relevant and on which there are some case laws. Now, one is ordinary transaction of merchants, bankers, financiers, and traders, such as those relating to mercantile documents, including enforcement and interpretation of such documents. So one of the issues which arise often is that is every money recovery suit a commercial dispute? To which the answer is clearly no, because the category set out is ordinary transaction of merchants, bankers, financiers, and traders. So if there was really a friendly loan given, then the recovery of that friendly loan cannot fall in the category of a commercial dispute, because the money recovery as such is not a clear category within the commercial disputes. So every category of money recovery surely doesn't fall in the category of a commercial dispute. One of the provisions which is litigated very often and on which there has been a great deal of case law is the category of agreements relating to immovable property used exclusively in trade and commerce. Now, in places like Bombay and a lot of other places in Maharashtra, where property has become one of the most contentious issues in courts, this clause becomes of great relevance. So one thing is very clear, that not every dispute relating to immovable property is a commercial dispute. It is only a dispute relating to arising out of agreements relating to immovable property used exclusively in trade and commerce. Only if an agreement relating to such a property is a subject matter of a suit and of beyond the specified value, that can it fall within the category of a commercial dispute and not otherwise. The Gujarat High Court and the Supreme Court interpreted this provision to say that when it says immovable property used exclusively in trade or commerce, it must mean a property which is actually being used in trade and commerce and not contemplated to be used in trade and commerce. So what happens in a situation? So suppose you buy an office premises in an under construction building, then it may not fall within the category of an immovable property used exclusively in trade and commerce. It may fall within the category of an ordinary suit and not a commercial dispute. There is Delhi High Court has seen a judgment, and when I mention the citations and the references of all these judgments, you will find in my note which I have set out. So in the Delhi High Court, one of the issues arose that suppose there is a leave-in license agreement or a rent agreement in relation to immovable property being used in trade and commerce for office premises, and a recovery of possession based on that leave-in license agreement, then all other issues regarding to mean profits, etc., would also apply and would fall within the category of a commercial dispute. However, it must be borne in mind that in cities like Bombay, where the jurisdiction of a civil court is barred from considering such disputes between landlord, tenants, licensed or licensee, then those disputes cannot be decided by the Commercial Courts Act, because the Commercial Courts Act clearly sets out that Commercial Court Act doesn't empower any civil court to consider any dispute, the jurisdiction of the civil court in respect of which has been barred. So in Bombay, that dispute will still go to, say, a small causes court. But in other places where there is the jurisdiction of the civil court is not barred, in relation to an office premises or commercial premises, these issues may go to a commercial court. So those judgments and citations also I have set out. The Delhi High Court has also held that when it says used exclusively in trade and commerce, that should be legally used in trade and commerce. So if somebody is illegally using, say, a residential premises for carrying on business, then a dispute in relation to that may not fall within the category of a commercial dispute. There are issues, other case laws, where on the basis of inheritance, there was a dispute in relation to immovable property on succession certificate. And it was held that these are not disputes, which are commercial disputes. Similarly, a situation of abuse of a power of attorney or a cancellation of a power of attorney, these disputes were held not to be commercial disputes. So there are wide and expansive definitions, but at the same time, it should fall within this category, which is set out in the Commercial Courts Act. And these are issues which will arise time and again. And at times, these will be vexed issues. One of the thoughts which I had, and one of the issues which I had was, let's take a situation where there is an agreement between an owner and a developer to develop a property, a land, for a building which will be exclusively sold for offices, etc., commercial building. Now, between the owner and the developer, the land is being used only for commercial purpose, that they will construct and they will sell. They don't have any other purpose except for construction and sale. They are using that property for a commercial purpose of development and selling. Then can such an agreement arise, such an agreement, and any disputes arising out of such an agreement, can that be a commercial dispute? Now, as I said, I would not venture to give you all answers to all vexed issues, because these are issues which will arise before you on some time. And these are issues which will have to be considered, considering the scheme of the Act and a large number of judgments which have already been rendered and which may come from time to time. So these are issues which you will have to consider. My idea is to just throw certain thoughts to you and leave you with some thoughts so that you are conscious of these issues as and when they arise. So this is the aspect of the commercial dispute. There are various other categories, and of course, if you were to touch upon all the categories, then we'll require one session only in that, and which is not possible. Then from section 7 onwards of the Act are this provision setting out the jurisdictions of the commercial division and the commercial courts and how the issues will be decided. One of the important provisions is the provision of section 8, which bars a revision from interim orders. So what is provided now is there are only limited categories of appeals in section 13 against which an AO is maintained from interim orders. From all other categories of orders, there will be no revision maintainable, and any issues which arise can be raised finally from the decree that may be passed in the suit. So there is a bar to a revision in section 8 of the Commercial Courts Act. The intention is to ensure that in these process of various remedies which are availed of from interim orders, the trial should not get delayed. The idea is to dispose of the trial and the suit itself as expeditiously as possible. Because in this whole process of multiple appeals, multiple revision, it has been the experience that the entire dispute gets, the resolution of the dispute gets delayed. So section 8 is an important provision. Now, section 11 is the provision which I had pointed out, that the Commercial Court Act doesn't empower a civil court to consider any dispute, the jurisdiction of which is barred for consideration of a civil court. So say, even if it is in relation to a commercial dispute, as a commercial premises, as I said, in the city of Bombay, because of the Small Causes Court Act, the civil court will not have jurisdiction to consider a dispute in relation to such a premises between a landlord and tenant. So that's something which we need to bear in mind. One of the issues which has been asked, and a query which has been raised by several of the learned judges, is the jurisdiction in cases of arbitration matters. Let me deal with it. In the case of arbitration matters, the Commercial Court Act does not in any manner override the Arbitration Act or expand the jurisdiction of the courts under the Arbitration Act. It has a limited role of identifying which is the court which will consider disputes under the Arbitration Act. It doesn't alter the scheme of the Arbitration Act, nor does it expand the grounds under Section 34 of the Arbitration Act, which has been a query of some of the learned judges, that does it make CPC applicable to arbitration proceedings and all that. It makes no difference to the scheme of the Arbitration Act. It is only an identification of which court will hear arbitration related matters, and that is set out in Section 10 of the Commercial Courts Act, which says that if it is a international arbitration, if it's a commercial dispute in relation to an international commercial arbitration, then all the matters will be considered by the commercial division of the High Court. So this was a provision intended to bring in a kind of more confidence of the international community in a dispute resolution in India, that disputes which arise out of arbitrations involving an entity which is not an Indian entity will be decided by the commercial division of the High Court. All other categories, if they fall within the jurisdiction of the High Court having original jurisdiction, they would be considered by the High Court or the commercial division of the High Court. Otherwise, they would be decided by the commercial courts. Now, the Arbitration Act has a provision that it shall be decided, all issues relating to arbitration will be decided by the principal judge of the district. So all arbitration matters will be decided only by commercial courts at the district judge level, and the Commercial Court Act does not in any manner empower the learned judges below the rank of a district judge to deal with the issue of arbitration matters. Similarly, in trademark and copyright matters, there are various provisions which says that these disputes shall be decided only at the level of the principal judge of the district and principal civil court of original jurisdiction in a district. And all these categories of disputes would have to be decided by the learned district judge or of that district, and cannot be decided by commercial courts below the rank of the district judge. So this would also answer, I believe, some of the queries which were sent to me. Now, coming next to one of the issues on which a lot of queries have been raised, and that is an issue relating to compulsory mediation. And that is a very vexed point, and a lot of queries have been raised to it. I wish I had a clear answer to it, but let me try and discuss it with you all as some of the points which I feel are relevant. Now, what does Section 12A say? It says that there is a mandatory mediation which has to be undergone before a commercial suit is filed, unless there is a urgent interim relief contemplated. Now, that is a provision which has caused a lot of complications and a lot of disputes. It says a suit which does not contemplate any urgent interim relief. So please consider this word contemplate. It is not where an interim relief is granted. It is a suit which does not contemplate any urgent interim relief under this act shall not be instituted unless the plaintiff exhausts the remedy of a pre-institution mediation in accordance with the manner. So there are two parts of it. It says shall not be instituted. So actually there is a bar of jurisdiction to that extent, but it gives a small toehold to a person and says if your suit contemplates an urgent relief, then the mandatory mediation is not required. And as has been pointed out by several learned judges in their queries, this contemplation of any urgent interim relief is being abused by a lot of litigants, and I'm sure on the advice of their lawyers, by saying that let's claim an urgent relief, then this whole mediation process is not applicable to us. Now, what is to be done in such a situation? Though there are judgments of courts which say that the mediation is mandatory, but yet there is one judgment of Telangana High Court, of which I have given the reference in my note, which says that the word used is contemplation of any urgent relief and not the entitlement of an urgent relief. So it is, if I as a litigant contemplate an urgent relief, then whether I would believe, then whether that relief is finally granted or not should not make a difference to the maintainability of the suit. So how do we really answer such a situation where the whole purpose of this act is sought to be defeated and a bar of jurisdiction is sought to be defeated? We cannot lose sight of the fact that a bar of jurisdiction cannot be read very widely. So it cannot be read so wide that the exception is rendered meaningless. So what happens in a situation that a party claims a frivolous interim relief and which is rejected by the learned judge? I think the answer to which is the provision for cause. So a party who just files a suit to avoid a mediation, and if his interim relief is found meaningless, then an interim relief application is found to be frivolous, then there can be imposition of heavy costs as contemplated under the Commercial Codes Act. And let's understand another thing. If a party is so hell-bent on not going on mediation, then how much ever we send him to mediation, there is a strong likelihood that he will defeat it in any case. So that's an issue which will have to have a final resolution by a higher court. But as on today, I would believe that so long as a party claims an interim relief and says that it is an urgent interim relief, till that time, the pre-institution mediation cannot be insisted upon. Now, let us take one example. There is an ordinary money recovery suit in which an urgent interim application under Order 38 Rule 5 is filed. And the learned judge holds that there was no effective grounds as required in law which are made out for grant of an application under Order 38 Rule 5. Now that is a point which the learned judge has decided, but the litigant might have very well considered that he had a very good case. Now, would it be right then to dismiss his suit on the ground that he wrongfully invoked the application for interim relief? So therefore, my view is really, and as the Telangana High Court has held, that the word contemplate means that a party seeks, and if he seeks, and even if he doesn't get relief, the pre-suit mediation is difficult to enforce strictly. And the learned judges surely have the great power of imposition of heavy costs in the matters to enforce this. So this is generally the provision of pre-institution mediation. One of the queries was what happens if a defendant does not pay the pre-mediation costs. My answer to that would be that if the defendant refuses to contribute for the pre-mediation costs, there is no provision in the rules framed for dispensing with that. I mean, the remedy of the defendant would be that either if he doesn't have the means to file a suit under section 33 of the CPC to seek appropriate relief for all costs in relation to the suit, which may involve a pre-mediation cost also. Otherwise, the mediation may have to be declared as failed. So I believe that this provision, though a very idealistic provision and believes that it may achieve a great end, how far practically, unless the parties have the mindset for a mediation, can this be altered and this be effectively implemented? Only time will tell us, only experience will tell us. So that is the issue on section 12A of the compulsory mediation. I'll be happy to answer any further queries. There were a few more queries on this, which you will find a response in my note, which I will circulate. Then the important provision of the Commercial Court Act are chapter 6 and section 16, whereby various provisions of the Code of Civil Procedure have been amended to give the civil courts a great deal of power and flexibility to monitor and ensure an expeditious disposal of commercial suits. Section 16 sets out a detailed amendment to the Civil Procedure Code, and that starts from the filing of the suit itself. It is important, and one of the learned judges has raised a very pertinent query, that can Commercial Court Act really succeed without the training of the department registry people also? I would believe that a training and a full knowledge of the Commercial Courts Act is as important for the department persons accepting the filing as it is for the lawyers and the learned judges, because the Commercial Court Act amends the CPC and has various requirements which are set out in the schedule from the process of filing itself. For example, the Commercial Courts Act now requires every document in the possession of the party to be filed along with the plaint together with a statement which is in the nature of an affidavit of documents. Earlier, in the ordinary suit, an affidavit of documents came much subsequently, where a person had to disclose every document in his possession which had a bearing to the suit, and he had to state that there is no other document in his possession beyond what he had done. Today, that has to be done along with the suit itself. And that is something which the department has to learn how to verify and see. There is a statement of truth which needs to be filed along with the affidavit. In relation to various electronic records, there are statements which are required to be filed in the nature of Section 65B of the Evidence Act. And one of the queries was, in light of the statements set out in the Commercial Courts Act, are the provisions of Section 65 of the Evidence Act, 65B of the Evidence Act mandatory? I would believe that the filing of this statement really serves the purpose of that certificate, and it has every ingredient of that certificate. And beyond that, no further certificate may really be warranted or required, because in order to narrow down the dispute, it is now provided that the certificate itself should be filed along with the plaint itself. If you all have a careful look at the Commercial Courts Act and the schedule of amendment, you will notice that there is a great deal of detailing as regards the verification to be done, the manner of verification to be done, and also the nature of pleadings to be filed, the manner in which a detailing of a claim of interest is to be done is also set out in the Commercial Courts Act. So when the commercial suit is filed, the pleadings must state the rate of interest claimed, the date from which it is claimed, the date to which it is calculated, the total amount of interest claimed, the daily rate at which interest accrues after that date, and a whole lot of detailing. Now, what will be the purpose of a commercial suit if these things are found lacking after 8 months of filing of the suit? Now, these are things which should be seen by the person taking the filing itself, and he should try to narrow these down, because it's a process of evolving. Both the lawyers, the learned judges, as well as the department people will grow with this legislation, but we need to apprise all of us ourselves of these provisions, and therefore the training of the staff is extremely important. Commercial Courts Act also sets out in great deal of length how pleadings are to be done. Some of these are ordinary requirements of pleadings, but which are often not followed by lawyers when they file pleadings. I often give this example that in my initial years of practice, I had a colleague who used to brief me to argue matters. And in his pleadings as a defendant, in the second or third paragraph, he had every conceivable objections under the CPC, starting with the suit is barred by limitation, the suit is bad from non-joinder, misjoinder, the suit is not valued appropriately, the court fees are not paid. And I used to usually ask him that why you have raised all these queries without any basis, and he used to say, let it be there, you never know when it comes helpful. So now the Commercial Court Act expressly sets out that you cannot just raise these objections without giving the reasons for those. You have to give reasons for each of these. If you are claiming that the court does not have jurisdiction, you must set out the reason why you are setting out that the court does not have jurisdiction. When you are denying a statement of fact, you must give reason why you are denying the statement of fact. And if you have a counter position to assert as regards the factual position, then you must set that out also. So these are important provisions. In the case of fraud, etc., of course, the detailing is required. These are important provisions to notice because the Commercial Court Act also gives great powers to the learned judges to strike off pleadings. And if pleadings are not in accordance with Commercial Courts Act, and if it is found that suppose an issue of jurisdiction is raised without any reason being given as required under the Commercial Court Act, it may be open for a learned judge to say that this issue is just a baseless issue without substantiation. I'm not raising an issue, unless, of course, there are issues of inherent jurisdiction of the court, which are issues of law, which can be argued at any time in any case. So these are the nature of requirements at the initial stage of the commercial suits. Then, of course, there are disclosures. Everything is set out. One of the two important provisions, I may fall short of time. Yalagada sir, how much time do I have? Around 15 minutes?
Yes, sir.
Okay, so I'll take around 15 minutes. So there are, as I said, the admission and denial of documents also have to be done at great length. It has to be bifurcated as to whether you're denying the correctness of the document, whether you're denying the existence of the document, whether you're denying the execution of the document, whether you're denying the issuance or receipt of the document. So it's not just easy, it's just simple to say that I'm denying this document. You have to set out what aspect of the document you are denying. And if you are denying a document, you have to also give reasons why you are denying that document. So you just cannot say that I'm denying this document and leave it at that. So either you say I'm not aware of this document at all or something like that, but you have to give reasons for denying these documents. And if the court finds that any party has unreasonably denied a document, which was required to be proved, then costs can be imposed by the court. And the costs here are actual costs. And therefore, it becomes a great deterrent for litigants to raise such issues. And if the power of cost can be implemented effectively, then that can be very effective in the case of commercial disputes. Also, if documents are not filed along with the plaint, then you only have a 30-day margin within which you can make an application to the learned judge saying that I had to file this suit in an urgent situation and give me time to file additional documents. After that, of course, it will be only in exceptional circumstances that certain documents can be permitted. So you are actually supposed to prepare your full trial before you file a suit in a commercial court, because the idea is that the whole thing should be disposed of within a period of 1 year. And there is in fact a chart which I have set out in my note, which you may have a look. Chaitanya, if you may just open the note, I'll show the chart of the time frame within which everything is expected. That is filing of the suit within 30 to 120 days. There should be written statement. Now this 120 days is, as you all may be aware, the outer limit beyond which the court does not have power to extend the filing of the written statement. And between 30 to 90 at 120 days also, you have to make out a good reason for the delay. So the idea is that within 30 days, a written statement should be filed. Thereafter, within 30 days, inspection. Within 15 days, admission and denial of documents. Within 4 weeks, the case management hearing. I'll just come to the case management hearing. Within 6 months, completion of oral arguments, and within 90 days, pronouncement of judgment. Now, I understand that this is a very wishful thinking with the lack of infrastructure, with the pressure of burden on our courts. This has hardly been achieved by any court, and whether they are the high courts or the trial courts or the district judges, this is something which is a wishful thinking, which most of the courts have not been able to achieve. Now, the case management hearing is a very important hearing. Chetan, we can get back to the screen. The case management hearing is a very important hearing, and that is order 15A, which is added to the CPC. That is, the court shall hold the first case management hearing within 4 weeks of filing of the admission and denial of documents, which has to be within the time frame. And in this case management hearing, the court has to decide a lot of important aspects. The entire future of that suit is really to be decided. How the future timetable of the suit is to be decided in a case management hearing. And this is a hearing where a lot of issues can get resolved. An important point is that it says that in a case management hearing, after hearing the parties, and once it finds that there are issues of fact and law which require to be tried. Now, though it says this much, I've never wondered they have not given any solution as to what happens if the court does not find that there are issues of facts and law which are to be tried. Does it mean that the court can decree the suit or dismiss the suit? Now, the kind of options available to the learned judges and what all the learned judge can give, the directions which can be given at the case management hearing are set out, where the learned judge can list witnesses to be examined, fix the dates of filing of evidence, fix the date on which evidence of the witnesses of parties will be recorded, fixing the date on which oral arguments are to be conducted. Even timelines for conducting arguments can be set out. Delhi High Court has in fact in one of the matters set out a timeline within which both the lawyers should complete their arguments. So there are a great deal of flexibility. In the case management hearing, the court has a lot of powers, and they are important, that the court may decide any pending applications filed. The court may direct filing of compilation of documents. The court may even ask parties to comply and attend hearings and evidence to be recorded on commission. The court may dismiss or give judgment on a claim after a decision on a preliminary issue. The court has various powers. The court has a power to strike off irrelevant evidence, inadmissible evidence. Even in the affidavit of evidence, the court is entitled to run through the affidavit of evidence and strike off things which are impermissible. As you all would have seen and noticed very often, lawyers at times make submissions in affidavits of evidence. The lawyers make put in evidence which is inadmissible in law. All that can be struck off from the affidavit of evidence at the case management hearing, so that the scope of evidence can also be curtailed. So please do consider the powers of the court at the case management hearing, and please do invoke these powers so that ultimately the trial of the suit can be streamlined and issues can be narrowed down, and lawyers are not given a free hand to keep on delaying matters, as we lawyers very often, when we have a bad case, tend to do. But that's where the realizing that the courts have been given great deal of power at the case management hearing. So this is one aspect which I would request you all to please consider at great length, and please do consider invoking the powers effectively at a case management hearing. One another important aspect of the Commercial Code Act is the power of summary judgment. Now, this is a very important provision which empowers a party before the settling of issues to seek a summary judgment. He can make an application for summary judgment. As you all are aware, earlier, the power of a summary judgment was really in the case of summary suits under Order 37. In other categories of suit, there was no provision for a summary judgment. But now the Commercial Code Act provides that it is open to both the plaintiff as well as a defendant before the framing of issues to make an application for summary judgment. And in that application, they can set out all the documents that they have in their support, all the evidence that they have in their support, and a plaintiff can come to court and say that the defendant has no real chance of succeeding in his suit, has no real defense to my claim. And equally, a defendant can come and say that, see, the suit is absolutely frivolous. There is no chance of the plaintiff succeeding in this claim, and therefore, please do not subject me to this trial. And that after giving the opposite party an opportunity to answer this application, the court can consider this application for summary judgment. And while deciding this application for summary judgment, the court has to decide whether in the case of a plaintiff, he has no real chance of succeeding in the claim, or in the case of a defendant, he has no real chance of defending the claim. And when it says real chance, the words are really that this claim or this defense is realistic and not fanciful. So it is not, as you used to usually say, these are all, I have always felt that though we keep using different terms, it would be illusory, moonshine. So this is the chance is not realistic, is realistic, not fanciful. And also a second category, that no other compelling reason, that there is no other compelling reason why the claim should not be disposed of before evidence. So the learned judge has to decide two parts. One, whether there is a real chance of succeeding in the claim or defense, and that there is no other compelling reason why the claim should not be disposed of before evidence. And what does this word mean? These words really mean that there is no genuine issue which requires a trial. And at the hearing of a summary judgment, the court has great power, including the power to impose conditions for defending or prosecuting the suit. the learned judge has a power to render a judgment on the claim, either allow the claim or dismiss the claim. The court has a power to pass conditional orders. The court has power of striking of pleadings. That's why I said that at times, the power of striking of pleadings is very important in this act. The power to proceed for a case management hearing, and the court has elaborate powers which are set out. So this is a very important provision and a great development in the Commercial Courts Act. Lastly, I would mention the amendment regarding costs. The Commercial Court Act makes it mandatory for the learned judge to consider the grant of costs. The costs are costs which are really compensatory costs, not the scale of costs which were earlier being considered. So you can actually compensate the winning party for the actual reasonable legal costs which he has borne. So reasonable cost is, suppose the court feels that there was no need for some, lawyers which they have engaged. Now, if for a small matter they get the top lawyer from Delhi to come and appear in a district court every time, and then expects the other side to bear the cost of that, that's something which the court can consider as not a reasonable cost. So everything, including legal fees, all travel of witnesses, and all these in the nature of actual costs can be awarded by the learned judge. The learned judge, while awarding costs, can bear various facts in mind as to how much of the claim has succeeded, how much has failed, did he make a frivolous claim, did he refuse a genuine offer of settlement. All these aspects can be kept in mind. And for not giving costs, reasons have to be recorded. So cost has become a norm and not an exception. Not granting of costs is an exception. So these are all tools which are given to learned judges to expedite the disposal of a commercial disputes. I think with the time, I've already taken 10 minutes more, Yarlagada sir, so we can go to the question answer session. I've received a few queries which I can either deal with them today, or I can send you a note with my responses to that, which can be circulated to everyone. But right now, if there's any query, I'll be happy to answer.
Sir, Yarlagada sir, your mic is mute in case you want to say something. Otherwise, I'll just ask. So helps her to see the questions. Saraf sir,
Yeah.
if you see the meeting chat, I have posted few questions over there. Considering that the time is a luxury right now, I'm sure you have already addressed few questions.
Let me just see.
So at the bottom where you have this option to disconnect the call and to share the screen, next to that there will be meeting notes or conversation, or rather conversation.
Yeah,
Right.
one. Show Q&A.
So you can you can look at the Q&A as well. That is also works over there.
Okay. There is a question: if an agreement between parties are silent on the point of ADR modes, in such circumstances, whether parties can be compelled to go to pre-mediation in a commercial dispute. Yes, this was also a query put to me, to which I was to respond. Yes, the general principle under section 89 was that there would be no requirement without the consent of the other party. There cannot be a mediation, but the Commercial Court Act does contemplate a plaintiff to mandatorily invoke the provision of a mediation. So I would believe that even if the agreement doesn't speak of an ADR mechanism, the mediation is a statutory mediation which needs to be invoked, and the entire thing has to be followed in accordance with the rules. Whether simple agreement to sell by a person in favor of a company can be treated as a commercial dispute, there is nothing in the agreement whether it is purchased for commercial purpose or not. I doubt, sir, whether that is so, unless it can be really shown, even if the agreement doesn't say that. If it can be shown and if it is pleaded in fact that it was for a commercial purpose, then whether the agreement says it or not may not be that relevant. What is relevant is that the dominant object of that agreement was an immovable property for a commercial purpose. Now, on this, sir, I also wanted to say that whether a suit relates to an immovable property or not is determined by the dominant object of that suit. So suppose there is a friendly loan of 1 crore of rupees, and for repayment of that loan, an office premises is given as mortgage. Now, a suit is filed for recovery of that friendly loan and enforcement of the mortgage in relation to the office premises. Now, that dominant object of that suit is not an immovable property. The dominant object of that suit is money. So in that case, the suit will not be an immovable property suit falling within the category of a commercial dispute because the dominant object is not there. So ultimately, it is not what the agreement says, but what the dominant object is. What is the remedy against interlocutory orders? The remedy is provided in section 13 of the Commercial Courts Act, and the category of appeals are restricted to those in the category of an appeal from order. Beyond that, no other appeals are permissible. Even a revision is barred. If a suit is filed seeking urgent relief and the commercial court finds that no such relief need be granted, then whether the plaintiff can be returned for compliance of a mandatory mediation, the procedure in the proviso to section 82 provides an analogous provision. As I've already broadly dealt with this, as I said, the word used is contemplate, not entitlement, and there is a Telangana High Court judgment to this effect. But we'll have to await a final clarity of a judgment of a higher court on this point. As of now, my personal belief is merely because a relief is not granted to a litigant doesn't mean that the suit can be returned. Now, that also has far-reaching consequences, because ultimately, if the person has not invoked mediation and this suit is also returned, his suit may become barred and he may have to claim the exemption of the Limitation Act for the period during which he prosecuted the first suit. And there again, the proof of bona fide and other issues will come in. So there can be a lot of complexity in returning that plaint also in certain circumstances. Whether the commercial dispute will attain finality after 3 tiers of litigation or 2 only, I would believe that the second appeal provision is not ousted in the case of a commercial dispute. But just give me one moment to just revisit section 13. I would believe that the second appeal 100 provision is not barred. Section 100 still continues in the CPC, and that has not been amended and not been deleted in the amendment to the Commercial Courts Act. So to that extent, I would believe that a second appeal on an issue of law may still continue, and that I've also set out in my note. Appearance of a defendant towards mediation fees in advance. Will it be proper to direct the parties to deposit certain amount? This provision is already there in the rules, where you will find that there is a provision of deposit of by both parties. There is nothing to require only the parties to deposit. That provision is already there in the rules, which requires both the parties to deposit monies. Whether a writ petition can be filed against an interim order of the commercial court. Sir, there is never a bar to a writ petition, but I mean, considering the scheme and the purpose of the Commercial Courts Act, I'm sure the writ courts would be very reluctant in exercising jurisdiction, so that the whole purpose of the Commercial Court Act is not defeated. And because all these issues can be raised from a final decree. How are the claims served on foreign parties? I think the ordinary means of service of summons is still there. There is no other, that's not been done away with. How to differentiate jurisdiction between commercial dispute court and debt recovery tribunal? As I pointed out, that whatever falls within the exclusive jurisdiction of the debt recovery tribunal will continue to be within the jurisdiction of the debt recovery tribunal, and that cannot be considered by a civil court of commercial division, a commercial court or commercial division. Yallagada sir, tell me when to stop.
Sir, I think you have covered almost all queries.
These extra queries, sir, they can be sent to me. I will try to collate all those in a day or two and try and see, send my responses to those.
Yes, sir. Only one interesting question.
Yes, sir.
You have said that party engages lawyers from Delhi and other places. Whether the cost of that lawyer from those places can be said to be reasonable cost.
Yes, sir. That is what I said, sir, that it is open to the learned judge to say that
Yes.
there was no warrant. This matter was not a matter where
Yes,
you
sir.
warranted a lawyer from Delhi. I'm not going to grant you a cost because that's not reasonable cost, sir.
Yes.
That is certainly an issue. And this is usually arises in arbitration, sir. These issues, international or commercial arbitration. There are times where parties engage 2-3 counsel and senior counsel from England and everywhere in arbitrations, and it is open to the arbitrator to say, no, this cannot be done. But one important part, sir, if the defendant had also got a lawyer from Delhi, then it cannot be said that the plaintiff getting the lawyer from Delhi was unjustified. So these are balancing which the learned judge will do.
Yes, sir. Sir, one more thing, with your permission, I may add.
Yes, sir.
Regarding the whether the suit is to be returned to the for representation, if the court finds that there is no necessity of urgent relief.
Yes.
I was saying the practice started when this commercial courts division started in the city civil courts Mumbai.
Yes, sir.
The practice adopted was that if such urgent relief suit is filed with a prayer for urgent relief, it was usually registered in a Kacha register and it will be placed before the commercial court judge, and there will be hearing on that urgent relief application. And if the judge gives a verdict that there is no such urgent relief required, and if he rejects that prayer, then he will return it for presentation. That is the procedure being adopted in City Civil Court Mumbai.
Sir, I don't find any such process being set out in the Commercial Courts Act, because while considering the plaint, it is a bar of jurisdiction, a bar which is there on the initiation of the suit. By considering an interim application, the learned judge has already exercised jurisdiction. Now, I doubt whether thereafter, after having exercised jurisdiction and entertained the suit, can the learned judge return the plaint? There is no provision for return. So that's an issue which is issue which will have to be.
So that is what many judges have raised the query in their queries, that by making such an application, parties can give a go by to this very purpose of compulsory mediation.
That is something my belief is, sir, that this act will have to have a clarity, or will have to have certain guidelines from a Supreme Court which will be binding on all judges. Otherwise, it is safer, in my belief, to go by the strict regime of the provision and entertain a suit rather than return a plaint. Let's take a situation, sir. I file a suit last 3 days before limitation, last 2 days before limitation, and that plaint, after consideration of the interim relief, is returned. Now, that is holding effectively that the suit was never properly filed. In the meanwhile, the claim has got barred by limitation, sir.
Sorry, sir. Here the interpretation, the practice adopted was there. The moment it is presented for pre-litigation, it is deemed to when that period is counted there.
No, I follow that, sir. But in a subsequent suit, yes, again, this period will have to be excluded. An issue of limitation will have to be framed that the period spent in the earlier suit will be excluded because of bona fide prosecution of that suit.
Yes.
So there will be various complexity in that situation. And sir, I also believe that our effort of sending this party to mediation is a effort which ultimately, if the person is so hell-bent on not going to mediation, he will just go there in 2 days, make the mediation fail and come back. So at the end of it all, as I said, these are beneficial provisions whereby only the judges cannot implement that. The mindset of the litigant, the mindset of lawyers will have to change, sir. Yes. So long as lawyers and litigants don't want to take advantage of such beneficial provisions, then it is very difficult to enforce strictly and ensure a mediation being successful.
Yes, sir. Anything, sir, you want to add further?
No, sir. I'm really grateful to you all for the interaction. I mean, whatever little I could gather, I have shared with you all. And in this much time, I think that's the highest I could manage. It was a good experience. And sir, thank you so much for your queries. It has given me a lot of food for thought and it's been a learning experience for me also. Thank you so much, Mr. Yellagada. Thank you to, and thanks to the Maharashtra Judicial Academy.
Sir, Mr. Chetan, with your permission, can I render the vote of thanks?
Sir, please. Thank you, sir.
Very good afternoon, honorable judges and guest speaker, Dr. Saraf sir, and my friend Chetan. It's a very good experience. Many judges were asking, many webinars were going on nowadays, whether the judges are going to have any such webinars, especially from the initiative of the academy. And with the ideas and the full support received from our Honorable Chief Justice and our Honorable Officiating Director and Registrar General and Registrar Inspection, Legal and all other Honorable Judges. This we started, and let me first express my vote of thanks for today's guest speaker, eminent advocate Shri Dr. Birendra Saraf, Senior Advocate. Sir, you have dealt with almost all the queries. I have gone through them. Almost all the queries, you have covered them, and at the end also you have taken the queries which were submitted during this session also, and you have covered all the aspects. The subject is very vast, sir, we know, and today I believe that we have covered almost the procedural issues, and in the next coming days we intend to have similar sessions with on all core subjects like arbitration, copyrights, patent, trademarks, Designs Act, Specific Relief Act, Contract Act, and the TP Act. These are the core subjects which we would like to have. We have many kinds of sessions, not speakers, sir. One speaker may present have different kinds of sessions, and important sessions which we need is how to deliver within the 1 hour. That is a really Herculean task, and sir, you have done it today, and congratulations. I express my thanks to you, sir.
Thank you, sir.
And I express my thanks to the none other than the SCC Online, their heads, Shri Malik and Shri Kapoor, and the anchor, Shri Chetan, and all their team members, without whose help this could not have been possible. And within a short period, I can say that within a hardly 3 to 4 days, we could do this. And therefore, I express my deep gratitude to the SCC Online and their team. Thank you very much, sirs. And I express my thanks to the Honorable Principal District Judges and the Principal Judges of the ex-cadre departments for rendering their full support. And I express my thanks to the master trainers and the young and tech-savvy judges also, who have in fact made this thing possible. Otherwise, we had some technical problems since yesterday we were doing, and you people have not only helped yourself and helped the other judges also. And therefore, I express my thanks. And I express my thanks to the registrars and their team who have made this facility available to the judges and timely brought the communications to the notice of the judges. And lastly, I express my thanks to my MGA team members also for rendering their cooperation. And sir, I believe that today's webinar is a very grand success, and I will definitely communicate all the responses to you all. We hope that we will meet again, and thank you very much. Jai Hind.
Thank you, sir. Anytime it will be my pleasure and privilege to come and share anything, sir.
Yes, thank you.
Thank you so much, sir. Thank you, Yalaga, sir. Thank you, Saraf, sir. And on behalf of everyone, thank you everyone for joining us today. As sir said, we will share the next schedule very soon. Have a good day ahead, sir. Now this session will be, I'll end this session, and we'll see you on the next one. Thank you, everyone.
Thank you so much.
Thank you, sir. Thank you.